Lawyers of Reddit, what is a detail that your client failed to bring up to you that completely lost you the case? Opposing counsel, isn't it true you hit victim in the face with a brick? Client, number, Marcus hit him with a brick. I hit him in the back with a piece of wood. To be fair, he'd sent a photo of his wife's beating face to his wife with a message saying something along the lines of this: "Do you want this to happen again?" He came across very well in court up to that point, but his mask slipped when that came out. Yay, sounds like someone I know. He can keep the mask on for a while, but it starts to slip when his perceived world isn't reality. A buddy of mine case as a public defender. A gal was busted on drug charges and told him she didn't have any drugs on her when they arrested her. He thought, okay, we'll use that. Turns out, she didn't have any drugs on her when they arrested her because she just sold them to an undercover cop. Technically she didn't have any drugs in her, LOL. My house was robbed. In addition to all the stuff the thief took, he also stole a bunch of my suits and all of my neckties. I had a big collection, like 100 or so. However, the thief left fingerprints on a hard plastic box that I kept spare change in. Fast forward 3 months, the thief is caught in the act of robbing another house in the same neighborhood. Same detectives on my case and this new theft. They fingerprint the guy and the fingerprints match the ones from my house. At the thief's arraignment, I see him strolling wearing my suit and my tie. I tell the district attorney. He says there's really no way to prove it. However, the tie he chose to wear was a one-of-kind street map of San Francisco and I still had all the documentation to prove it. The district attorney's eyes widen and he informs the judge. The judge has the thief placed under arrest again for possession of stolen property. The thief's lawyer was dumbfounded. It was a nice end to a rough situation. I hate that this happened to you, but I love this story, hahaha. Custody case. Client failed to tell me he was previously convicted of felony child abuse for breaking 16 bones in an infant's body. Sometimes I wish we could stone people. Company I worked for at the time was doing due diligence before acquiring a small tech startup. The COO of the tech startup was a well-liked guy in the company, friendly and outgoing. Though we had heard rumblings that the COO was rather hands-on with the work and with female employees. Apparently there was a walk-away package proposed to the COO that would let him keep a sizable portion of his post-acquisition bonus because a young woman who worked in their sales department had filed HR complaints against the COO and obtained counsel. I sat in on the meeting with the COO and the company's retained lawyers while they grilled him about his contacts with the young woman. The COO denied ever having contact with her within the company without multiple other people present. Those people said his behavior toward her in the meetings didn't raise any flags. The COO emphatically denied having any contact with her outside of work. The lawyers asked the question a half dozen different ways and each time the COO denied any out of work contact. Later we meet with the woman and her lawyer with the COO not present. Her lawyer gives us a rather graphic card that came with a bouquet of flowers addressed to her from the COO. The guy had an account with a florist linked to his credit card. When the company retained lawyers confronted him, he said, "But I never had contact with her. It's not like I delivered the flowers myself." COO got terminated for cause, so no walkaway package. At her request the woman was given PTO until after the acquisition, then moved to another one of the companies under our umbrella. I'm sorry for laughing, but reading your comment all I could see was COO all over the place, and now I can't get the idea out of my head that a pigeon in a top hat wrote this. Lawyer in the UK. I acted for a member of a famous diddler hunting group. My client was charged with various offences relating to his vigilantism. Most seriously, causing grievous bodily harm with intent. He wanted me to fight the case on a public interest defense point that is not available to him in statute or at common law, contrary to my advice. I followed his instructions as I'm bound to do. If the state won't punish diddler properly, then it's left to men like my client to take the law into their own hands. A horseshit argument for a whole host of reasons. His laptop was seized by police and submitted for forensic examination. He had a staggeringly huge database of chili pea on it. He himself was a massive diddler. I beat up diddlers in my spare time. No one will suspect a thing. Minor traffic cases can be the worst for this, believe it or not, because they are short and simple and oftentimes the client isn't there. So if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case, 70 miles per hour in a 55. No big deal. If she does a driving improvement course, the court will usually dismiss or reduce those, since her driving record wasn't bad. When I showed up for her, I found out that she had been driving 70 up an unplowed snow lane to get around all the other cars traveling in the lane that had been plowed because they were driving too slow. I didn't know it was even possible to drive 70 on fresh snow. The officer stated he'd already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he didn't feel comfortable reducing it under those circumstances. When I called her up after court to confirm, she did claim she'd just forgotten to mention it. Now maybe I've lived too much of my life in the South, but that just boggles my mind as a detail you'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour class, and she should probably just go ahead and pay this one. I legitimately do that all the time during consults. Give my honest assessment if the case is even worth doing, and so by omitting that detail she harmed herself for no reason. At least she took it well and didn't get defensive. Friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically this guy took an AC unit and threw it at his girlfriend. My buddy tells me he was able to get a plea deal for 1 year probation, no jail time. The judge is all ready to accept the deal when he asks the defendant if he had anything he would like to say. The defendant responds, "Yeah, I don't know why they charging me with assault. I never touched her. I just threw an AC at her." This is bull's. Judge rescinded plea deal because of defendant's attitude, lack of remorse. Went to trial and got a year in jail. The idea of having an AC unit thrown at me is honestly terrifying. Client said his ex owed him a lot of money and that she was trying to get out of paying him back by getting a protective order against him. Seemed reasonable, so I took his case. At the hearing it came out that they were never a couple, that he was sending adult toys to her residence on a weekly basis, and that she never asked for the thousands of dollars he gave her over the years. Stripper. We lost. He got laughed out of court and he learned a valuable lesson. Tell your lawyer the good and the bad stuff before trial. My dude in a custody battle where the opposing party claims he has a drinking problem and he denies it 1000%. Even after the real talk I have with him asking him to not hide crap from me, and to be honest, we go into court and at cross-examination the opposing party provides video evidence of him finishing work, driving to an abandoned parking lot to drink a few tall boys, and then going to pick up his kid from school. Every single access visit, he not only didn't tell me that, he forgot to mention that his ex's brother owns a private investigator firm. Freaking idiot. That he filmed his offenses for his YouTube channel. The cops didn't even know. A witness brought it up on day 3 of a trial. It was a nice quick change of plea that afternoon. Case as a paralegal. Negligence case. Client argued that a lack of street lights and a cyclist he couldn't see was responsible for him hitting a wire pole. Upon discovery, the first respondent's report indicated that they found the driver in the driver's seat, pants down, with P playing on the phone. Wasn't difficult to figure out who was negligent at that point. Your Honor, if the cable repairman had simply fixed the cable in accordance with professional standard practices, my client would have had no other recourse but to keep his ostrich in the corral on the evening in question. Employment case. We got to the deposition of my client and all set up. The first question is, please state your name. The client looks at me and says, can we take a break? We do, and she pulls me out in the hall to tell me she's lied to me about her identity. She's apparently a serial fraudster and has changed identities 7 times since the 90s. She apparently thought the other attorneys had somehow figured it out, and that's why they asked the question. Guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before, because the law said that for his conviction, he could only request modification twice for any one sentence, regardless of if they were granted or denied. Swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record basically, finally arrived. He'd personally filed for modification 6 times since he was sentenced with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. I'm a court-appointed attorney for qualifying individuals and family matters. Termination of parental rights case. Have been fighting to argue that parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic meds anymore, ready to be a parent, etc. After a few months of negotiating with all the parties and Department of Children, Court Services, we have a pre-trial to try and convince guardians. I meet with my client before the hearing to see if anything changed. Nope. All good. Let's get my kids. Great. That's not happening today, but let's try. We get going in court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals 1. That no longer is working. 2. No longer in apartment. 3. Doesn't want to have a relationship with guardians despite her kids loving them. 4. Won't send her kids pictures of the toys they miss and can't have. 5. Plans on moving out of state. 6. Thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant, all in the matter of 15 seconds. I was too shocked to even react. Speechless. Not the image of stability and parental fitness I've been trying to paint since last July. Client was working really hard to get everything right, and legitimately had everything going for her prior to this hearing. I was not making false representations or trying to get a monster reinstated. This was a true bombshell as I did my due diligence to make sure things were on the up and statutory requirements were met. Things fell apart very fast apparently. This was a very atypical situation. Parents typically do a really good job working hard to meet their requirements. Not my client, but the son of the opposing party, and presumably the party himself, lied about being blind to make himself seem more sympathetic as a witness. We didn't know either until he took the witness box. Their counsel asked him to take the oath, and he picked the card up and read it. That was the cherry on top of a series of ridiculous events. The judge dismissed the whole thing in our client's favor shortly after. I was a trainee at the time, but my boss, who was in her late 60s then, said it was the most ridiculous case she'd ever handled. And he picked the card up and read it. I was expecting he easily walked up or sat down, not that he was stupid enough to actually read something out. I wasn't a lawyer in this role, but was a law clerk. This was a typical divorce case. This particular jury trial was about splitting assets and who would get what. It was a long drawn out case that took about 5 days. Right before the closing arguments, the attorneys wanted to talk to the judge. It seems as though a couple of days prior the couple decided to get back together, and instead of telling the judge and their lawyers, they just kept it a secret. We heard 4 days of evidence, arguments, brought in experts such as land assessors, financial planning people and the like, and they were back together. One of the attorneys asked to be dismissed from the case immediately and walked out the courtroom. The judge had to dismiss the jury, and the couple was adamant that they didn't think that them getting back together was a detail any of their attorneys needed to know. Yes, in some states there are jury trials for divorces. However, this particular case wasn't for the divorce, but for a cause of action stemming from the divorce, marital property. It was a jury trial. I'm a public defender in an area with lots of MUs. M makes most people talk a lot. So I can't tell you how many clients forget to mention that they got to the jail still high and called their mom girlfriend buddy on the recorded jail phone and not only confessed to the crime, but also brainstormed whatever alibi or version of events I'm relying on to defend them. I'm seeing this question a lot, so I'll add some info here. This is not legal advice, just explaining things a bit more. Calls to a lawyer are privileged and generally go through dedicated lines that aren't recorded, depending on the facility. Calls to family, friends, etc. through the normal phones are not privileged, are generally recorded, and can be used in court. There are usually printed signs near the phones and a recorded warning before each call that this is the case. I heard of a guy trying to appeal his disability benefit being revoked. He was supposedly a paraplegic, but the opposition had over 10 minutes of video footage of him walking, running and even jumping over a fence. After the 1-minute mark, the judge said, "Okay, I've seen enough. Please leave." Credit card theft fraud case. When I was a young lawyer back in the late 80s, I was trying this guy on a CC case and the witness was the department store clerk. Before video surveillance, the state relied heavily on witness identification. As she described the customer that was purchasing the very unique clothing her store sold, I asked her how could she be so sure it was my client. She looked at my client, who was wearing the most obnoxiously yellow shirt imaginable, and said, "Because not only does he completely match the description I just gave you, but he's wearing the exact same shirt I sold him." The jury convicted him and I learned that day to better prepare my clients for trial. There's a rule you're supposed to follow when questioning trial witnesses, and that rule is to never ask a question you don't know the answer to. Despite this rule, lawyers often ask small, apparently inconsequential questions which are necessary to set the scene but are so inconsequential or obvious that their answers are fairly presumed. This case was an exception to that general presumption. The defendant was arrested on a warrant and transported to jail. After booking him into jail, the officer returned to his vehicle and discovered a baggie of drugs sitting right in the middle of the back seat. The defendant was charged with possession. At trial, the officer explained that he routinely searches his vehicle before his shift starts and after any time he transports someone in the back seat. The defense attorney tried to poke holes in the story, but the officer's testimony was remarkably consistent. The officer was fastidious about checking his vehicle. The appearance of the drugs coincided with the defendant's presence in the vehicle. Then, as the defense attorney was running out of questions, he threw out the question, "Was there anyone else in the backseat of the vehicle?" It was a Hail Mary. Even when there are multiple arrests, police tend not to transport more than one arrestee at a time if they can help it. There was no reason to believe anyone else could have feasibly been in the backseat with the defendant. Though it's no surprise to you, the defense attorney and prosecutor were stunned when the answer came back as yes. Turns out, the defendant was with his girlfriend when he was arrested, and the officer courteously agreed to drive her to her apartment before taking her boyfriend to jail. This fact was not included in the police report. The officer never told the prosecutor, and, shockingly, the defendant never told his attorney. There was a palpable pause as this fact sunk in. Since there was another person in the back seat, there was more than enough reasonable doubt. Proofs were concluded and the prosecutor threw out a half-hearted closing. The not guilty verdict was a given. Because of this case, I learned to never assume a fact, no matter how obvious it may seem. I am actually a lawyer, but I was only watching this trial, not participating. So the case was that woman A had hit woman B in the head with a heavy beer pint at a bar, and woman B got pretty serious injuries. The defense claimed that woman A had not hit anyone with the pint, but instead had just thrown the pint into a random direction, and it happened to hit B in the head. Thus it was an accident and not a battery. Well, the prosecution had a CCTV tape from the bar, and it was shown at the trial, and the tape clearly showed in HD as A walked behind B and smashed the pint to her head so hard that the pint shattered on impact. I looked at the defense lawyer and his jaw literally almost hit the table. The prosecutor also noticed this and asked something along thrown A, and the defense lawyer said that due to technical difficulties he couldn't get the CCTV tape open on his computer when he was reviewing the evidence. Woman A was found guilty, so yeah, I was completely dumbfounded. My father is a judge. I remember him talking about a case where a woman was suing for a severe back injury that she said was preventing her from working and taking care of her kids and so on. In the middle of the trial, a pen rolled off the table and she is bending over trying to reach it from her chair, but pen was too far away. So she stands up and bends over and picks it up and goes back to her seat as if nothing is out of the ordinary. My dad is just looking at her and she snaps at my dad and goes, "What are you staring at?" My dad asked her if she was okay and her response was that she was fine. Her attorney leaned over and said something to her and she then loudly started complaining about her back and how much her back hurt, but no one believed her, lol. And it's not even my stories but my dad's. He was working as a fraud investigator for an insurance company. I have a few stories of his, but here's two of them. Guy was claiming theft of multiple items but mainly a ring. Things weren't adding up, so my dad and the insurance company's lawyer decided to do a depo of him. Guy shows up and is doing the depot when my dad notices the guy is wearing the exact ring he's claiming was stolen. My dad slides a note to the lawyer telling him the guy's wearing the ring. Once the note got slid, the guy realized what happened and put his hands under the table and took the ring off. They asked him to stand up and lo and behold the ring fell to the ground. Another one is a guy claiming a break-in and theft. Immediately things weren't adding up as the window was broken out instead of in. The guy submitted Polaroids of items he claimed were his, like TVs and such. Thing is, in the Polaroids you could see the reflection of the store they were in on the glass. He also claimed numerous CDs records, but oddly enough every single one started with an R, S, or a T. We're talking hundreds of CDs records. My dad was about to deny the claim in person but noticed he had a gun on the table, so decided to do it over the phone. Ready for an escalation? Later the same guy was arrested for beheading a prostitute and throwing her head in the river. That went from 0 to life in a heartbeat. This one ended my marriage. Well, it was the start of the end of marriage. My husband lost his job in the title mortgage business, applied for unemployment, got denied. I decided to help him with his appeal hearing. I asked him multiple times before the hearing, is there anything you did that caused them fire you? He says no, absolutely not. They fired him out of nowhere. Hearing day comes. He testifies under oath that he did nothing wrong, was a good employee, no issues. Upon cross-examination, the other attorney pulls out documents from one of his real estate closings. Documents he forged and backdated. Had to admit he perjured himself. Needless to say, he didn't get unemployment and he didn't sleep at home that night. Not my case, which is a gift from above, really. Civil trial before a jury for injuries and prop damage from a MVA, and punitive damages because defendant was intoxicated at the time of the accident. Let's call defendant DUI. Almost doesn't need to be said, but before DUI ever stepped foot in court, they would have been prepped repeatedly, first for the deposition and then for trial testimony, with the standard questions. Were there any prior incidents, arrests, convictions, anything that can be used to impeach any of DUI's testimony, yada yada. Over hours, denies everything and is as clean as a clean whistle. Thus, at trial, defense counsel, DC, puts DUI on the stand to give them an opportunity to tell the jury of their contrition for this one-time error in judgment, describe the difficult time DUI was going through at the time, and otherwise show themselves to the jury as an upstanding member of society in order to reduce punitive damages. It goes well. Then plaintiff's counsel, PA, gets to cross. I'm going to paraphrase what allegedly happened next, which is purely hearsay. PA, earlier, you testified that this was a one-time mistake and you've learned your lesson. Is that correct? DUI, yes. PA, isn't it true that you've already been convicted of DUI in another state? DUI sits silent as DC immediately objects, but it's properly overruled and DUI must answer. Since what happens next is impeachment, I'll skip the objections, but suffice to say they were being fired off as rapidly as a machine gun, and just as rapidly overruled. DUI, yes. PA, and isn't it true that, in your prior DUI, a child died? You can imagine what's happening in the courtroom and, most importantly, amongst the jury. And you think it's over. Stick a fork in DUI. It's done. But then, PA goes for the jugular. Do you remember the name of that little child that you killed while you were driving while intoxicated? Imo. This question is one for the ages. More powerful than the old when did you stop beating your wife? Because no matter how you answer, and that is why you never, ever lie to your attorney. Not me, but my mentor. This is the reason you never ask questions that you don't already know the answer to in court. During the trial with the judge on a divorce matter, the wife brought up that he had abused her during the course of their marriage. Client whispers to my mentor that that is absolutely not true. On the stand, during his portion of testimony, my mentor asks, at any point in the marriage, did you lay your hands on your wife? One time we were having an argument and I held her down on the couch until she stopped arguing with me. What? My mentor said it was like she could see it happening in slow motion and all the alarm bells were going off in her head because he had never mentioned this, and apparently, to him, this was not abuse. The judge gave wife a lot more money as a result and husband was baffled. My mentor was fuming. ETA. Husband admitted this was the only time he had laid hands on wife. My mentor was more peeved because she had thought the case was in the bag since wife had abandoned the kids with husband to run off with her lover down in Florida and literally only came back to the state to get the divorce done. Husband had been noted as being a great dad to the kids and a good figure in the community, hence why she was so dang shocked at his answer. But your honor, I wasn't using my hands. If you are new to the channel, you can subscribe. I publish new videos every day. Until then, check another video. Bye for now.